published. I did a bit of digging, and on the Supreme Court website, there's a little note at the bottom that says, as a broad indication, judgments tend to follow between 3 and 9 months after the conclusion of the appeal hearing, although in some cases it may be earlier than that. Perfect, I thought. 9 months is the 2nd of September 2022. So we'll definitely have a judgment by the time of my talk. That means there'll be loads to talk about. It'll be very topical. The Supreme Court will have given clear and definitive guidance on the question of whether the court should be concerned with alleviating the detriment or fulfilling the expectation. But instead, as the weeks ticked by, tumbleweed. And in my perhaps more optimistic moments, I even wondered whether the Lords had got wind of my talk today and were holding off to see whether they could pick up any helpful hints or tips on which way they should go. Sadly, I've scanned the guest list, and unless they're here under a pseudonym, they seem to have missed it. If they are here, though, you're most welcome, and I hope you find this talk illuminating to everyone else. The question of remedy is a really interesting one, partly because there's very strong jurisprudential reasons for both sides of the argument, but also partly because the question has been so obviously dodged by the Court of Appeal on more than one occasion in the last few years. Everyone's slightly on tenterhooks to see which way it will go, if it will go any way at all. So do keep your eyes peeled for judgment when it comes out. Promises to be fascinating to the extent the court decides to address this fundamental question. Anyway, very quick précis, even quicker because I know Jack's dealt with it already. Elements of proprietary estoppel generally presented in 3 stages. This is McGarry and Wade. I use it because it's on my shelf, but also because it gets cited in quite a few judgments as well. And it's a pretty good, pithy summary. The owner of the land introduces, encourages, or allows the claimant to believe the claimant has or will enjoy some right or benefit over the claimant's property. So not always a beneficial interest. It could be an easement, for example. Provided that the inducement is not specifically limited to mere personal use of the land. So that would allow an easement, which is a proprietary use of the land. Secondly, in reliance on this belief, the claimant acts to his or her detriment to the reasonably determined knowledge of the owner. And then finally, the owner seeks to take unconscionable advantage of the claimant by denying the claimant the right or benefit for which the claimant expected to believe. Lots of you will be familiar with this. Representation broadly is A, reliance is B, detriment and unconscionability is tied up in C. So that's a short, pithy summary. But I thought I'd go through again quite quickly, but in a little bit more detail, some of the key principles that were highlighted helpfully by Lord Justice Lewison in the case of Davis and Davis 2016 case. And these principles are useful because they were cited with approval in Guest in 2020 by the Court of Appeal, and it remains to be seen whether they survive the Supreme Court's consideration. Some of these are more interesting than others, but they're all important. And if you're ever running a proprietary estoppel case, I suggest that the 9 principles, again, unless they're overturned, are stapled very firmly to your wall, and that you consider each in detail applied to your case, whether you are a claimant or a defendant. The first is this: deciding whether an equity has been raised, and if so, how to satisfy it, is a retrospective exercise, looking backwards from the moment that the promise falls due to be performed, and asking whether in the circumstances which have actually happened, it would be unconscionable for a promise not to be kept either wholly or in part. Comes from Thorne and Major. That's a little bit of a mouthful, but the key things to take from that are that the proprietary operates from the moment the promise falls due, but hasn't been satisfied. So it's a retrospective exercise from that particular point. Secondly, it's all about unconscionability. The second principle there, ingredients necessary to raise an equity are assurance, reliance, detriment. We've seen that already. Thirdly, no claim based on proprietary estoppel can be divided into watertight compartments. Jack was talking about this earlier. He envisaged I would be talking about it as well. I will only very briefly, but safe to say that assurances, reliance and detriment all bleed into each other in certain cases. So be aware of that factor. Fourthly, detriment doesn't need to consist of expenditure of money. Really important, really obvious in lots of farming cases, particularly where it's labour. But it does, as point number 4 suggests, has to be something substantial. Number 5, there must be a sufficient causal link between the assurance relied on and the detriment asserted. Again, going back to what Jack said, if you were going to carry out the behaviour with the detriment anyway, then that is reliance. Goes on to say the issue of detriment must be judged at the moment when the person who is given the assurance seeks to go back on it. The question is whether, and if so, to what extent, it would be unjust or inequitable to allow the person who's given the assurance to go back on it. The essential test on unconscionability. That's a little bit of a repetition, from my mind, from point 1 or some of the major points of point 1. But cites a different case there, Gillett and Holt. So that's 5. 6, the essence of the doctrine of proprietary estoppel is to do what is necessary to avoid an unconscionable result. Comes from Jennings and Rice. Really important case. Jennings and Rice often gets forgotten now, I feel, because it's 20 years ago and we've had a few more Court of Appeal decisions, but they all refer to it in quite some detail, and some of the points I think are best made in that particular case. But looking at that number 6 and looking forward to what we're going to be talking about, which is alleviating detriment versus fulfilling the promise. The fact that Jennings and Rice talks about the essence of proprietary estoppel, doing what is necessary to avoid an unconscionable result, might be a little bit of a push, a little bit of an indicator towards alleviating detriment as opposed to fulfilling all the promises. Number 7, in deciding how to satisfy any equity, the court must weigh the detriment suffered by the claimant in reliance on the defendant's assurances against any countervailing benefits enjoyed in consequence of that reliance. Henry and Henry Privy Council case, recent case 2019, I think. And yet, just an always important one to bear in mind that when you're doing your trotting up, there are 2 sides to the balance sheet. Detriment on one side, but if they've got free accommodation, often the case in farming cases, then that is something to be weighed against the work that is done, or indeed if they've been paid to some extent, that is also an obvious benefit. Doesn't mean that they'll strike down the claim entirely, or that they will alleviate the unconscionability, but they can count or should be counted against it. Number 8, we're getting there, I promise. Proportionality lies at the heart of proprietary estoppel. The doctrine of proprietary estoppel permeates every application, so says Henry and Henry. In particular, there must be proportionality between the remedy and the detriment which it is purposed to avoid. This does not mean the court should abandon expectations and seek only to compensate detrimental reliance. But if the expectation is disproportionate to the detriment, the court should satisfy the equity in a more limited way. Again, Jennings and Rice, again, there, so, giving with one hand, taking with the other, that very much saying that we shouldn't forget about fulfilling expectations, we shouldn't abandon them. But if your expectations are far greater than your detriment, then you are unlikely to receive the entirety of that expectation. And finally, we got there, number 9, in deciding how to satisfy the equity, the court has to exercise broad judgmental discretion. However, this discretion is not unfettered. It must be exercised on a principle basis and shouldn't be based on palm tree justice, portable palm trees, etc., etc. So this is the court at pains to point out that, yes, even though it might seem a little bit stick your finger in the air, it's definitely not. Judges are definitely making principle judgments based on principles of law that have been set down previously, even if it might feel a little bit overly discretionary. For those of you who haven't come across it, what is mentioned by portable palm trees, scratching your heads, it's actually a biblical reference and refers back to wise old men dispensing wisdom and justice sitting underneath palm trees, and basically makes the point that it can't just decide things on broad principles of fairness. The law has to apply, and that's the emphasis that is made in that point 9. So those are our 9 principles. I now want to move on to 2 types of case. I say this with a little bit of a caveat because there's been some judicial criticism of this distinction. Nevertheless, I still think it's worth bearing in mind. And the first is the quasi-contractual case. And quoting Jennings and Rice here, who was quoted approval in Davis and Davis, the court said, the assurances and reliance have a consensual character, not far short of a contract. In such case, both the claimant's and the claimant's expectations and the element of detriment will be defined with reasonable clarity. In that kind of case, the court is likely to vindicate the claimant's expectations. So this, from my mind, is really important because what it's saying is that if both sides understand, i.e. the promisor and the promisee, understand what the promisor is promising and understand what the promisee is going to do, i.e. detriment, then you have clear parameters in which to operate, and no one's surprised when the court upholds the promise that's made, because even if one went through a complete bean counting exercise, the detriment might not be worth the promise. If that's what's been agreed between the parties clearly and isn't wholly disproportionate, it's likely to be upheld. And emphasize the word likely is used here, and the court is likely to vindicate the claimant's expectations. So it's not an absolute rule, but nevertheless, it's an important one. So if the promisor says to the promisee, you look after me, my house and my garden for no pay for the rest of my days, and you'll get the house in my will, that will be an example, and in fact, perhaps it's documented in a letter or something, and so everyone can be relatively sure about it. That might be the kind of case which the court views as a quasi-contract, and therefore there's much more of a likelihood of upholding the expectation. That is to be contrasted with uncertain expectations, or cases which I call disconnect cases, where there's a disconnect between the promise that has been made and what the claimant actually believed that they were going to get. So if you look at it from an objective point of view and just say, well, I don't quite understand why the claimant thought they were getting that, even if you believe the claimant thought they were getting that, but you don't understand it based on what the words said and the deeds done by the promisor, then we're in this kind of territory. So again, Jennings and Rice says this: if the claimant's expectations are uncertain, then their specific vindication cannot be the appropriate test. In other words, claimant's not really sure, then the court shouldn't really give them what they think might possibly be what they were promised or what they were led to believe. A similar problem arises at the court, or those satisfied that the claimant has a genuine claim is not satisfied that the high level of the claimant's expectations is fairly derived from the deceased patron's assurances, which may have been justified only on a lower level of expectation. Again, a bit of a mouthful, but a roundabout way of saying if the claimant believed X, but you can't really objectively find X in the promises made by the promisor, then that's going to be another example of a case where the court may still take the claimant's expectations, or the upper end of any range of expectations, as a starting point. But unless constrained by authority, I will regard it as no more than a starting point. So 2 types of case: quasi-contractual, or the uncertain expectations / disconnect types of cases. And to go over it again, to recapitulate, there's a category of case in which the benefactor and the claimant have reached a mutual understanding, which is in reasonably clear terms, but does not amount to a contract. In such case, the court's natural response is natural response, not absolute response. Note, is to fulfill the claimant's expectations. Contrast with if the claimant's expectations are uncertain or extravagant or out of all proportion to the detriment which the claimant has suffered, the court can and should recognise the claimant's equity should be satisfied in another and generally more limited way. How does this play out in practice? Well, really good example of the quasi-contractual case, because we're going to be concentrating primarily on the other type of case for the rest of this talk, is Rojob and Deb, recent case from this year. In broad terms, claimant's husband and wife, defendant was a very close friend of theirs. Husband operated a business, the husband and wife lived in a home, business got into difficulty, home was secured, possession proceedings issued against the claimants, and they were faced with the prospect of losing their house. In swept their guardian angel, the defendant, who said, look, transfer it to me, and I'll raise a mortgage of £205,000 against this house, which was worth, under agreement, about £300,000. I'll raise this mortgage and I'll give it to you. You can pay off your debts, and then you've saved the house. So this is what happens. Property is transferred, mortgage raised, given to claimants to pay the debts. Claimants carried on living in the property. They paid the mortgage. They carried out renovations, but they then sought to buy back the property for the £205,000 that they said had been agreed between them and the defendants. Now, there was a dispute as to whether was the defendants agreed there was a buyback provision in their whole agreement. He said it was for 3 years and strictly time limited, so that once the 3 years passed, they had no right to buy back the property at any price. So they clearly suffered detriment. What the court did, firstly, was consider whether there was this 3-year time limit on the buyback provision, and it said no, there wasn't. It was open-ended, so it's a question of fact. It could be operated at any time. Have they suffered detriment in this? Because on one level, they'd avoided bankruptcy, which is clearly a positive. They got to stay in their own house, again, a positive, and they got £205,000. So, relatively all rosy. At the same time, the £205,000 was undervalued by quite a considerable amount. They'd also paid the mortgage themselves, and they paid renovations of the property. The court found that proprietary estoppel was made out. And once it did so, crucially for our consideration, it was always going to be a quasi-contract case, because the agreement was transfer to my name for £205,000. You can buy it back. You can buy it back for that price at any point in the future. So what the order the court made was, if the claimants can get their £205,000 back, the defendant has to sell it to them for that price plus the associated costs of sale. So a really clear example of a quasi-contract case. Moving on, getting to the heart of our dispute as to alleviating detriment versus fulfilling the promise. Well, what's the case for alleviating the detriment? A couple of quotations here. Firstly, Jennings and Rice. In an endeavour to do what is necessary to avoid an unconscionable result, or alternatively to identify the minimum equity to do justice. So very clearly based on equitable principles, proprietary estoppel being equitable remedy, and the question of unconscionability. So once you get rid of the detriment, the unconscionability, then that's all you need to do, the minimum justice. And Davis and Davis, logically, this is Lord Justice Lewison, there's much to be said for this, the second approach, since the essence of proprietary estoppel is a combination of expectation and detriment. If either is absent, claim must fail. If, therefore, the detriment can be fairly quantified and a claimant receives full compensation for that detriment, that compensation ought, in principle, to remove the foundation of the claim. Now, it's important to say that that's not Davis and Davis deciding that simply removing the detriment is the way to go, and that's not how one should read the ultimate result in that case. It's clear that Lord Justice Lewison was probably attracted to that argument, even if he didn't decide it. And you can summarise this up in broad terms by saying The job of the court in an equitable case is to prevent harm or unconscionability. If you can alleviate that harm by removing the detriment, i.e. funding the detriment in some way, then your job is done and you don't need to do anything more, which seems quite persuasive. But then, of course, the other side of the coin also seems relatively persuasive as well. Here's Haberfield and Haberfield, again, a Lord Justice Lewison case. If A and B have made a bargain which B has kept, then in the absence of countervailing factors, it will be unethical, or if you prefer unconscionable, for A not to keep his side of the bargain. And then James and James, this is the first instance, His Honour Judge Matthews' decision from 2018, who very much comes down on the side of fulfilling the promise. Proprietary estoppel is a doctrine which, like the law of contract, focuses on expectations created rather than losses suffered. So if A promises B some property right, intending B to rely on this, and B does rely on it to B's detriment, natural impulse is, as with contract law, to require A to make good that expectation. Making the remedy proportionate to the detriment suffered would be to focus more on what B has lost rather than what B expected to gain. Now, it's important to note in this case, the claim for proprietary estoppel such as it was failed. And so these remarks to some extent were overturned, and they're also first instance remarks when there are Court of Appeal judgments surrounding it. So a little bit of a cautionary word in relation to that. But what comes out of that is, so just going back very, very briefly, the doctrine of estoppel is based on promises made and expectations created. And whether it would be unconscionable to row back from those promises. So if the court was merely concerned with alleviating a detriment, the promiser would be able to resile from their promises and escape without meeting them in full, without meeting them to the full extent. So still actually a benefit there to not keeping your promises, because you might only have to pay slightly less than your promises, which doesn't seem a particularly equitable way of doing things. Enter the sliding scale in between these two polarities. This was proposed first by Leslie Bowen KC of St John's Chambers. You'll be hearing from him if you attend the next seminar, final seminar, in fact. And he proposed this sliding scale as follows. What is not entirely clear from this passage is what the court is to do with the expectation if there is, it is only a starting point. Mr. Bloom suggested that there might be a sliding scale by which the clearer the expectation, the greater the detriment, and the longer the passage of time during which the expectation was reasonably held, the greater would be the weight that should be given to the expectation. I agree this is a useful working hypothesis. So again, another thing to pin up on your door, I'm sure many of you know about it already. If you don't, clearer the expectation, greater the detriment, longer the passage of time on for which the expectation was reasonably held. And if taking those into account, the greater those things are, the more likely you're going to get your expectation fulfilled rather than your detriment alleviated. But much as Lord Justice Lewison was interested in Davis and Davis in the question of the debate as to which side to prefer, he concluded, perhaps with an element of relief, fortunately, I do not think we are required to resolve this controversy on this appeal. It didn't, however, stop him substituting his views, the first instance judge's reasoning, without noticeably applying or explicitly applying the sliding scale. He did so seemingly on the basis that there was insufficient reasoning that had been given by the first instance judge. Perhaps more generously, he disagreed with the first instance judge's assessment of what the claimant's expectations were at any particular time, given that they clearly evolved, changed, and in some circumstances reduced during the time period. So it's a slightly complex, nuanced judgment, but it was surprising, from my mind, that that Lord Justice Lewison jumped right in and swapped his own opinion for the first instance judges reducing the value down from 1.5 million to £500,000, so quite a considerable amount. Sliding scale not expressly revisited in Haverfield by Lord Justice Lewison, which might tell you something. In James and James, His Honour Judge Matthew says, "For myself, I respectfully doubt how far a sliding scale approach would be useful. Just as a contract is either made and broken or not, either the promisor is creating expectation on which the promisee has resolved to his detriment, to his or her detriment or not." In other words, very much fulfilling expectation. Again, unsurprising from His Honour Judge Matthews. But Lord Justice Floyd in Guest respectfully agreed with the sliding scale approach, but did caveat by saying, "I would not regard this list of scaling factors, i.e. the three summarised in Davis and Davis, as more important examples of as more than important examples of the considerations which come into play." We haven't got a great deal of time, so I'll whiz through this very quickly, but there's an entertaining, perhaps, debate about the question of the importance of proportionality. Part of the judgments, says Jennings, most essential requirement and must be proportionality between the expectation and the detriment. This creates confusion because actually what he meant was between the remedy and the detriment, i.e. if you can't have a remedy that's out of full proportion to the detriment. But a little bit of cold water poured on that by Lady Justice Arden in Suggett, who says, "In my judgment, this principle does not mean that there has to be a relationship of proportionality between the level of detriment and the relief awarded." Slightly puzzling given what had come before in Jennings and Jennings. She says, "So the question is, was the relief that the judge granted out of all proportion to the detriment suffered?" That for her is the important question. But His Honour Judge Matthews, again, keen on fulfilling the expectation, looks at this first sentence. "In my judgment, this principle does not mean there has to be a relationship of proportionality between the level of detriment and the relief awarded," and says, for what it's worth, I agree with Lady Justice Arden. But cold water thrown in Haverfield by Lord Justice Lewison, who doesn't like her formulation, but does agree with her final question. This question, so the question is, whether the relief that the judge granted out of all proportion to the detriment suffered? And Lord Justice Lewison makes the point saying, well, it's not an exact bean counting exercise. Proportionality is broad brush. So it's not a question of mathematical precision. Like in all cases in which court decides to have satisfying equity, it must exercise with judgmental discretion and will do so in a flexible way. All of which brings us on to Guest and Guest. Very briefly, farmhouse near Chepstow, parents David and Josephine, children are Andrew, Jan and Ross. Andrew, 9 years old, and Ross works on the farm his whole life, paid a small wage, never really more than £11,000 a year. But he does live in the property or a cottage on the farm rent-free. He's an innovator and a moderniser. He obtained qualifications and diplomas, dealt with the administrative side, including accounts and subsidies and so on. He increased the productivity of the farm. Ultimately, though, he fell out with his father, the relationship broke down completely. He left the farm. First instance, he got 50% of the farming business, as well as 40% of the farm property, subject to a life interest for his parents. The ultimate result of that, which I think was common ground, that the farm and the business were going to have to be sold in order to satisfy that. Now, the interesting element of this case is, of course, he was told that when his parents died, he would get at least half the farm, possibly all the farm property, and that he would get the business when his parents retired. But his parents hadn't retired, and they certainly hadn't died. So under this order, there's been an acceleration of Andrew's interest given by the first instance judge. So he's got it sooner than he would have otherwise have got it. So that creates an interesting dilemma, and it was one of the major grounds of appeal to the Court of Appeal. And appeals made essentially on three grounds. Firstly, the subjective expectation was wrong, and the court should only look to avoid unconscionability. By subjective expectation, what the appellants meant was, well, it doesn't matter what the claimant believed in his head he was going to get, unless that can be substantiated by promises that were made by his parents. The court shouldn't use that as a starting point for determining what he was ultimately going to receive. Secondly, the court should do the minimum equity, and that can be satisfied by alleviating the detriment. That's the second ground of appeal. And the third allowed ground of appeal was the anticipatory point. So in essence, Andrew got his rewards too soon. This was all rejected by Lord Justice Floyd, not Lord Justice Lewison, but quoted here at paragraph 48 of Guest and Guest. Lord Justice Lewison went on to discuss, without finally resolving what he described as the lively controversy about the aim of the broad judgmental discretion. Is it in effect to give effect to the claimant's expectations unless it be disproportionate to do so, or is it to ensure that the claimant's reliance interest is protected till he or she is compensated for detriment suffered only? That controversy is much ventilated in academic writings of both scholarship, etc., etc. Now, what happened in Guest and Guest was really important. The final thing that you need to pin to your walls is the approved list of factors that the court will consider that might have the effect of reducing fulfilment of the promise that was made. And Lord Justice Floyd outlined various factors. So, for instance, if there had been misconduct by the claimant, if there had been particularly oppressive conduct on the part of the defendant, the need for a clean break, the court cannot compel rather than comply people who have fallen out to live peacefully together. Alterations to the promisor's assets and circumstances over the course of time. So if the promisor has lost significant amounts of money over time, or if in fact they've gained large amounts of money, that will have an effect on how the court exercises its discretion. The effect of taxation is going to be really important, and other claims, legal, moral, on the promisor or his or her estate. So a really important example of that would be other siblings who might have a claim on the farm. But we would add, of course, into this the question of whether it's going to have to result in an order for sale. That must be a relevant consideration, and it was in Guest and Guest, albeit His Honour Judge Russin in first instance was quite happy to make the order, knowing that it was ultimately going to have to result in an order of sale of both the farming business and the property. So there we are. The Court of Appeal was rejected on all three grounds, but permission was granted to appeal to the Supreme Court. That was heard, as we know, on the 2nd of December last year. So here are the key things to look out for from the judgment when it comes. Should it go further on providing guidance on the alleviating detriment versus fulfilling the promise debate? Well, we don't know. We'll simply have to wait and see. Will it accept the acceleration of Andrew's interest? Will it say, yes, in these circumstances, even though Andrew was only going to get these things later on, in this case, the court had a broad discretion, needs to resolve the issue today, is therefore justified in making the order that it did. And finally, should less priority be placed on what the claimant expected rather than what was actually promised? So in cases like farming cases often are, where the promises are vague, the families use their own familiar family language, I think was the phrase that was used in Gillett and Holt, and the court can't easily discern what the promise was. Should actually there be so much reliance placed on what the claimant expected in his own head? Or should in fact the court look elsewhere at the words that were said, or perhaps even just trying to relieve the detriment that has been suffered? We've run a little bit over time, my apologies for that, but that was a very quick gallop through the hearty debate that is ongoing, or in some cases being avoided by the Court of Appeal, and we await to see what happens with the Supreme Court judgment. I'm just having a little look, and there don't appear to be any open questions. And given we have run over time, I think it's probably best to call it a day there. Thank you very much, everyone, for attending. And I look forward to seeing you all at the next event on the 5th of October, and then the final event on the 12th of October. And that final event, as many of you as possible in person. Thank you very much.
Thank you.
Thank you.